live. I will start by saying good evening. I am Susan Angolia, and I am the Communications and Membership Services Manager for NYCDS. I want to welcome everyone to tonight's webinar on avoiding pitfalls in the hiring process with speakers Dennis Alessi and Brent Pohlman with the law firm Mandelbaum Barrett, a corporate friend of NYCDS. Before the program starts, I'd like to briefly introduce tonight's presenter. Dennis Alessi is a partner at Mandelbaum Barrett, specializing in providing strategic compliance counsel to employers and healthcare clients. He helps businesses manage workforces, navigate federal and state employment laws, and address regulatory investigations and employee disputes. Dennis offers valuable guidance on employment policies, handbooks, and forms while conducting educational seminars for managers to mitigate risk and avoid litigation. When necessary, he adeptly defends employers in various employment matters in both federal and state court. Additionally, Dennis's practice includes handling complex healthcare litigation and ensuring compliance with the ever-changing industry regulations. Brent Pohlman is a partner at Mandelbaum's Labor and Employment Practice Group. He brings extensive expertise in representing employers in complex civil litigation, covering civil rights actions, whistleblower claims, contract disputes, wage and hour cases, and other employment disputes. He is adept at navigating federal and New Jersey state courts and appearing before key administrative agencies. Additionally, Brent offers invaluable guidance to employers in policy development, day-to-day workforce management, including employment agreements, and training on topics like anti-harassment, anti-discrimination, and disability accommodation. Thank you.
Thank you, everyone, for joining tonight. Tonight's presentation will be divided into 3 parts. The first part we will be talking about is protected classes of applicants for employment. The second part will be other no-nos in the posting and recruiting and hiring process. And the last part will be best practices for advertising and interviews. So here is Dennis and Brent now.
Okay. Thank you. So let me just say preliminarily that there are quite a number of laws that protect different categories of applicants for employment. And we're not going to go through all of them. The 3 big ones are the federal law, Title VII, which prohibits discrimination in employment, which includes people applying for positions. And there are classifications of individuals who are protected by that statute. The other 2 main statutes are the New York Human Rights Law, New York State, and then there's also the New York City law. And the 3 laws overlap quite a bit in terms of what categories of employees, or what categories of employees, what categories of individuals applying for employment, are protected from discrimination in hiring decisions as to whether or not they're hired. And so we're not going to go through all those categories because some of them we've concluded really not particularly applicable with dental practices, but we're going to go through most of them and discuss who's in that category and some aspects of what it means that they're in a protected category when they apply for a position with a dental practice. So Brent's going to start off with the first group.
Yeah, and before we start too, just like to remind everybody, although we're 2 lawyers talking about legal topics here today, this does not constitute legal advice. And so, if you hear something, if you're educated on something today, or you're dealing with an issue that we discuss, the details of every specific employment candidate issue are unique. And, a broad overview may not cover that. So, of course, if you have any specific legal questions, you really can't rely on this as legal advice, but rather, guidance to kind of educate you about these issues. And you should always speak to your lawyer. Also, we will be discussing some rather sensitive topics in a blunt manner and in a manner in which you would be confronted with them and have to address them in your workplace. And so, at some point today, we may use some language in some scenarios that seem somewhat coarse or and could be offensive, but it's certainly not our intent to offend, but to educate and to raise everybody's awareness as to the different situations in which you may have to address these issues. And in the real world, you may have to address these in very uncomfortable situations sometimes. So just wanted to say that to you before we get going today, everybody. As my partner Dennis stated, we're going to begin by talking about the protected classes. And, the three major laws that Dennis identified, within them state that these laws protect or pertain to what we call protected classes. And those are individuals, whether they're candidates or employees, who satisfy the criteria of each class. And when these laws were first drafted and adopted many decades ago, there were much more limited number of protected classes. And over time, that's expanded. And it's expanded recently. And so, as Dennis stated, we're going to start by going over those which we think are most relevant for you and your practices. And I'm going to begin by talking about race and color. Everybody says, well, okay, that's easy. It's been illegal to go ahead, Dennis.
Age.
Oh, I have age first. Sorry. We're going to begin with age, and age is another one that's been around for since the inception of most of these laws. And in fact, there's a federal law known as the Age Discrimination in Employment Act that addresses just that issue. And so, of course, everyone knows, well, yeah, I can't discriminate or refuse to hire against somebody because of their age. Well, how does that come into play in the hiring process? And how does that come into play when I'm interviewing? So, one thing to be aware of is when a candidate comes in and, they may seem that they are older, they may have more experience than they're looking for, or you may be concerned how much longer they're going to work. Those aren't factors that we can consider, because unless the position's for a set number of time, a set period of time, and the candidate tells you, yeah, I know you need to fill this position for 2 years, I only want to work for 6 more months, well, then they're not going to be able to satisfy an objective criteria for that position. However, having a conversation with a candidate in which you say, so how much longer do you think you're going to work? Or, boy, you're going to be able to do this much longer. Or, and those are questions where if the candidate isn't successful in obtaining the position and you don't hire them, they may go back and say, boy, was my age a factor in why I didn't get this job? And they're going to talk to a plaintiff's lawyer, and they're going to ask him that. And that could become the basis for a false allegation that you discriminate against them. Even conversations that seem just very cordial and friendly, such as if you're having just a general conversation with somebody about, what their interests are, what's going on. And, you say, boy, how much longer do you think you're going to work for? And it's sort of not meeting it in a way that you intend on discriminating them, but as a conversation piece. And that's something that we can't ask. And even though it may be meant in an innocuous, not offensive manner, it could become a piece of evidence in a litigation against you. And so, there's going to be an overarching theme today that Dennis and I are going to talk about, and that's being very aware about what you're saying when you're involved in this recruiting and interviewing and hiring process. And so even very friendly conversations can sometimes touch on topics and phrases that may be offensive. And so with respect to age, it's not just, oh, I didn't hire that person because they're a certain age. We want you to be aware in the hiring process of the questions that you ask. And those questions are, how much longer do you think you're going to work? Oh boy, you're going to retire soon? And those type of items.
Well, there's
Dennis?
one other thing I want to mention, that there's actually been some plaintiffs' attorneys that have been using this for nuisance lawsuits. You put out an advertisement, and a natural thing to put in an advertisement is 3 to 5 years experience. Some plaintiffs' lawyers have used that kind of advertisement to say that that's indicative of age discrimination in your hiring practices, because 3 to 5 years of experience, the argument is that's got to be somebody who's fairly young if they only have that many years experience. And so as a result of those cases, we've actually been counseling clients that when you put out an advertisement is not, I know that that's a common point that's made, but you probably should not specify that there's an upper limit of how many years of experience the person should have that you're going to consider for the employment. Because the idea being, you go through applications and you see somebody that's got 20 years experience, and that goes into the circular filing cabinet, the waste paper basket. That's, that was used as the basis for a lawsuit actually against a law firm. But also I've seen it in other contexts. So you have to be careful with your advertisement. I just wanted to throw that in.
And I think that's a good way to conclude on the age issue at this point. And so we'll move along to our next protected class.
Race and age, race and color.
Race and color. So, right, this is another one. Long time prohibition. Everybody knows you can't discriminate against employees based on their race, their color. And so I don't think that's something that I need to get in detail with anybody here about and how that would and how that comes into the interview process in the traditional way. What I want to kind of talk to everybody about was the idea that individuals of the same race can discriminate against each other. And so, very often, there'll be people who will say, "Oh, I can't believe this candidate is accusing me of discrimination. I'm African American. He was African American. How can that happen? Or I was Colombian and he was Colombian. How can that happen?" And the reason is that just because you're of the same you're the same race or color doesn't mean that you or an employer can't discriminate against somebody who's of that same race and color. In fact, there have been many decisions that the courts have handed down that reflect that individuals can discriminate against members of their own race. And so the reason I want to raise that is because most people aren't aware of that. And it's important that even if you're dealing with a candidate who is of the same racial background as you or the same color, you still have to be very careful how you speak to them and to the issues you raise. And you can't feel as though just because, well, they're the same as me, it's another white guy, it's another African American, what I say in the decision-making process can't come back to say that I was discriminating against them or didn't hire them based on their color. Because if they come to find out that the successful candidate was African American and they were white, or they were African American and a white candidate was hired, and they can look back to that interview process and find that maybe there was a comment made that you thought was comfortable or you thought was appropriate given your similarities. They may use that to hang on to and go and bring a claim and say that this was a discriminatory decision. And so what we want to remind you there is just be aware that just because you're of the same racial background and the same color as a candidate does not mean that they cannot successfully bring a claim against you for racial or color discrimination.
So let me go on to the next one, which is creed. On its face, that probably seems pretty easy. You can't discriminate against someone because they're whatever religion they are. They're Catholic, they're Muslim, they're Wiccan, or whatever. And it goes beyond just sort of the recognized religions. I mentioned Wiccan because that came up, quite frankly, with COVID-19 and having to make accommodations. It does not have to be, one of the main recognized religions. If you have your own system of belief, that would be covered, because in fact they don't use the word religion, they use the word creed. So you're not going to get anybody, this day and age, I don't think any dentist is going to ask them, well, what church do you go to? But the real issue there is accommodation, which is something that the U.S. Supreme Court just dealt with recently, and quite frankly raised the bar for employers in terms of how much they have to accommodate. So let me just give you a couple of examples that would probably be very relevant in New York. Someone comes in, woman, let's say, great, to be a dental hygienist, great credentials, great background. This is wonderful. You tell that person, well, we do half days on Saturday. I've got another hygienist. So you'll have to work like one Saturday a month. We're open from 9 or 8, whatever it is, till 1 o'clock in the afternoon. And they tell you, well, I'm a very religious Jewish person and I'm not working on Saturday. What do you have to? What does that come in? Now you're talking about, to what extent do I have to accommodate? And that's not an easy decision to make, because there's no bright line. So, for example, the Supreme Court case where the fellow was well, he was actually Christian, but it was the same deal. He didn't want to work overtime on the weekend, on Sunday, because he would be in church. And the court said, well, the fact that it's going to cause some, disruption, that you'll have to reschedule staff and whatnot, and other people had to work overtime to cover for him. They didn't really see that as enough of a burden that you couldn't accommodate the guy. All right, that's the Postal Service. I don't know how many staff they had at that one location, but if you're a dentist and you've got 4 employees, so if that person's not going to come in on Saturday, that means then that your one other hygienist now has to work every Saturday. The analysis may be a little different. So it's very, very fact. I get that word out. Very, very fact specific. So what you do in that situation is say, okay, fine, I'll look at that. We'll see what we're going to do. I would not make a decision at that point. Well, I can't really consider it at this point. And then then you call your lawyers and you talk to them and decide what you're going to do. Another example, which I think is very, very relevant in New York, is with the increase in the Muslim population, Muslim women. I know when I'm in Manhattan for work, I see more women than I ever have in the past, wearing the headscarf and whatnot. And so if you have someone who comes in to be interviewed for a position and they are wearing the headscarf, you cannot ask them if they're Muslim, that, because then the argument can be made that, well, you're making a decision on their employment based upon the answer to that question, and that's probably the kind of accommodation to allow that person to wear the headscarf that you probably would have to do in that situation. So the real issue with creed is not that you're going to ask someone what their religion is and not hire them because they're a particular religion. It really comes down to the issue of accommodation and how much you have to do to try to accommodate.
And one point to raise on some of the more obscure issues that may come up is, we've seen some EEOC decisions as well as some judicial decisions dealing with tattoos and piercings that are that have religious connotation. And certainly in the dental industry, your assistants and your hygienists are working in your patients, right? They're working in their mouths. And you may see that somebody has a tattoo or they may have a piercing. And there's certainly some Asian and East Asian faiths in which piercings are part of the religion. And so having a policy, against tattoos or visible tattoos or piercings, and screening out a candidate based on that, without knowing if that's they have that for a religious reason. I mean, there's some that are obvious and you can tell they're not, but it's something you need to be aware of, and that certainly, you should seek counsel on if you have questions or you have concerns about whether or not it would be appropriate not to hire somebody due to a piercing or a visible tattoo.
And then the next category, this one we'll probably spend a little more time on, and a few of the others I think we may have to get through them a little more quickly, just so that we keep with the agenda. But the next one, we've kind of lumped a whole bunch together, and that is discrimination based on sex, sexual orientation, whether you're gay or heterosexual, your gender ID, whether you identify as a man or a woman, regardless of what you were at birth, and your sexual expression. That would be, for example, if you're clearly a guy but you like to dress like a woman, that's sexual. That's how you express yourself. So those are all, because we're in New York, are all protected categories. And there, I have not seen anything yet on that says that you have to accommodate that. I mean, the concept of accommodation, I think as time goes on, is going to come across all these categories. But I don't know, Brent, maybe you have, but I haven't seen anything yet that says, if someone walks in who's clearly a guy, clearly is a cross-dresser and is dressed like a woman and all made up in a very feminine way, and you look at that and go, oh, I have a very conservative patient base where my practice is, you know, I'm in Staten Island, and they're not going to really be really appreciative of a dental hygienist that's a guy, you know, dressing like a woman with high heels and makeup on. You know, I don't know that that's really something where, you know, you'd have to accommodate that they dress that way. But I don't know. But what's your thought on that?
Well, so you know, this is where we sort of get into hiring overlaps with our policies and procedures, because you know, the EEOC and you know, this is one of the new areas, right? You know, sort of sex, gender, and sexual orientation have been protected classes. You know, gender has been a protected class since the outset of these laws, and in New York, sexual orientation has been a protected class for a very long time. But you know, the federal law does not protect gender identity or gender expression at this time, but New York State and New York City do. And so, you know, we can't refuse to hire an employee based on their gender identity or gender expression. But as Dennis said, accommodating how they want to dress, particularly in a dental office, is a different issue, because as a dental office, you know, most of our clients, you know, they don't have their employees don't have the right to come to work in whatever they choose. There's you know, designated attire. Sometimes it's branded, sometimes it's not. And you know, if your practice is such that you say, hey, I don't care who you are, from the newest employee to our most senior person, if you have this job, this is what you wear to work every day. I would agree with Dennis that we haven't seen any decisions that say that you have to deviate from a recognized dress code that exists for both hygiene, exists for branding purposes, to accommodate somebody who says, well, I don't want to wear pants and a scrub shirt. You know, that's not what I like to wear. Then in that case, you know, that job may not be for you. You know, but it's how we're treating all of are we treating our employees equally, and are we applying this equally is the question. And when it comes to hiring, you know, at the outset, if you know, if there's a concern that you have with a candidate who you're concerned about how they may want to dress, of course, talk to counsel, but something to say to them is, say, you know, just so you know, we have a dress code here, and our dress code is such, and it's going to apply to everybody. And I agree with my partner that I haven't seen anything that says that you can't enforce that or apply it.
One thing, because particularly in New York, where we have such a diverse group of people and how they dress, what we've really counseled our clients is two things. First of all, have a written dress code that includes jewelry, makeup, you know, extreme hairdos and coloring, all those sorts of things. Because if you have an established policy, which you've applied across the board, it's going to be very hard for someone to say, well, you discriminate against me because, you know, I'm a cross-dresser. I'm using, I guess, the most extreme example, but it makes the point. No, I didn't discriminate against you. We have a policy here. Here's our established policy. It's in our manual. It was adopted 5 years ago. It's across the board. The other thing, so that's the first thing, having a policy that you can cite to and say, it's got nothing to do with you personally. This is our policy, and we do enforce it across the board. The other thing, too, a lot of our clients have gone to, quite frankly, is scrubs. You know, well, first of all, regulations are from the dental, you're supposed to have their name, but their, you know, their dental tech, their dental hygienist is supposed to have what title they are, so people don't think maybe they're a dentist, you know. You're supposed to have that. But most of our clients have really, we counsel them to go to scrubs with the name of the practice on it and whatnot, and say, no, everybody here wears scrubs, and that's what you have to do. So then it's going to be very difficult for them to claim you discriminate against me because whatever I do. No, everybody wears scrubs, and that's the policy, and you have to do that. So that's, I think, how you deal with that issue. The next one is national origin, and here Brett had said, oh, we may say things that may offend some people, but they're being said for a purpose, to make an example. So we were talking about this Monday. We're preparing for this presentation. What are we going to talk about with national origin? National origin is different than race. National origin is what country you come from. So you could be white, black, brown, purple, and all come from one country. And what type of discrimination this prohibits is the fact that you come from that country. So recently we had a situation where I had a couple of people call and say, they think I'm Russian. And I could see that as soon as I walked up in my mouth, I had a definitely, Eastern European accent. And they thought I was Russian, and they were very hostile. In fact, they were not Russian. They were from another Eastern European country. That's national origin. And some of it goes back to what Brent had said earlier. I've been told over the years by quite a number of Hispanic people that there's kind of like a pecking order in Latin America that I don't know if this is true or not, but I'm using this as an example that, Argentinians and Brazilians consider themselves to be basically at the top of the social strata in Latin America. And everybody kind of agrees and says that the Puerto Rican people are at the bottom of the social strata. So if someone is not hired because they're considered lower down in the social strata because of the Latin American country they come from, that would be national origin discrimination. And as Brett said earlier, even if the person's from the same country, they may look at this person and say, oh, they're a low life. I know exactly who they are. They're from one of the favelas in Brazil, and I'm not hiring them, even if they were Brazilian themselves. That's national origin discrimination in a nutshell.
And we'll move along but briefly, we just wanted to raise the issue of military status, which is a protected class. Not just under state law, but there's a federal law. It's USERRA, United States Service Member Employment and Reemployment Act. And just we want you to be aware that, particularly now, there have been a lot of people over the last 2 decades who have gone in the service and come out of the service, and they may be in the reserves. And when you interview with them, they may tell you, hey, I'm still a reservist. And there are a lot of people in the dental industry who did serve. There are a lot of dentists in the military service. I happen to represent a doctor who was a dentist in the military for a long time. And knowing they may disclose to you, oh, well, I'm in a reserve, so I may have to take some time. I may maybe have to do a mini deployment, or I may have to go for 2 weeks a year to here. And the law is very clear. That cannot be, if it is an inconvenience, if it is a pain, if it's hard to schedule around, that's not a factor that you can consider. And that if an employee is not hired because he's saying, well, I know you're going to have to get deployed, or I know you're going to have to take 2 weeks in February to go, down to Fort Hood to provide service. And that's why you don't hire them. You're going to have some liability. And so it's more of an obscure issue, but it does come up, and it does come up in the dental industry. And we just wanted you to be aware of that.
Right.
Next is on our list is pregnancy. This is certainly a major issue for a lot of our clients. The dental industry, it's not a secret. A lot of the staff members are women, and it's a lot of women who are, in their 20s, 30s, and 40s, and a lot of women who are at the stage of their life where they're having children. And so, the easy answer is somebody comes in, and the easy example is somebody comes in and they're pregnant. And of course, you can't discriminate against somebody because you see they're pregnant. And everyone knows that. And I'm going to assume that I don't need to tell anybody that. But some of the questions that Dennis and I wanted to make you aware of, things not to discuss or to discuss about pregnancy, because that can lead to litigation. So if you're interviewing somebody and you say, oh, hey, so, are you married? Do you have any kids? All right. Could see a normal conversation. I talk to people every day and you're like, oh, do you have any kids? What's going on? But I'm not interviewing for a job. And so when you're interviewing somebody for a job, raising that issue, that now says the person says, well, do they consider that I might have kids, or I might be having kids if I don't have them yet? Blatantly asking them, do you intend on having children? And we understand the disruption to a small dental practice by having a hygienist, a dentist, an assistant leave is significant. It's hard to find replacements. It's a very significant disruption, but that cannot be a criteria that's considered in the employment decisions, because you will be exposed to significant liability. Another sort of question that could lead to that is, have you taken any paid family leave? Do you plan on taking any leave? Those are the kind of questions that, while not directly related to pregnancy, because I'm sure nobody's going to directly, say, discriminate against a pregnant woman who's a candidate. It's these other questions that could come up in the process that could, by asking them, could lead you to potential liability. Even if you want to know, hey, is this person going to be here in 6 months from now? If they tell you, well, I might have a child next year, that can't be considered in the hiring process. Dennis?
Yeah, there's a closely related, and that is family status. In New York, if you have your family status is also protected. So, for example, it's not just pregnancy, but if you have children, and let's say in passing, because don't forget, if someone I think we should make this point. Someone may volunteer, an applicant may volunteer information that you could never ask about. But if they volunteer it, well, they volunteered it. Okay, so they say, well, I got 3 kids. I got 3 lovely kids. I really enjoy having my children, and they volunteer that. Okay, but then the problem comes up is, well, how do you take care? You would be working here, 4 days a week, one night late, and Saturday till half the day and whatnot. What childcare arrangements do you have? Ooh. And then if you do not hire that person, then they can say, well, they discriminated against me because of my family status. So just because someone in passing may volunteer information, and that happens a lot. I get a lot of calls, I'm sure Brent does also. Well, they told me this. Okay, well, maybe they said that to you, and they disclosed something that you could never ask about. But you then cannot follow up on that and ask that question. Well, you got 3 kids. What do you do for, what do you do for childcare? Are you going to be able to be here the times that I need you? Now, there are some, I would say that support staff going out on pregnancy is probably that, and staff going out on disability, probably the 2 questions, Brent and I talked about this, that we get the most. And I get a phone call and go, I've got 5 support staff. The second one's just going out on pregnancy. I've just lost 2/5 of my support staff. What am I supposed to do here? You can't let them go. You can't. In fact, in New York, under the statute, they've got 12 weeks of paid leave, and they have job protection. And you can't say, well, I have to go out and bring in a temp, even if you can find one, and it's going to cost me 1.5 times what it cost me to pay that person, and that's a burden. That's probably not going to be sufficient in the current situation, because it's not an accommodation issue. While hiring a temp person at 1.5 what it cost me for you is a financial burden, so I don't have to accommodate you. Not in New York. It's 12 weeks of paid leave, assuming that they've worked long enough and that, and they're entitled to that benefit, and they have job protection. So the only way I could say to you that you might want to deal with that, and it's really a terrible problem. Remember, these laws were not enacted for an employer that's got, whereas they've got 4 support staff and they're all women and they're all of childbearing age. The law wasn't geared to that, but you're held to the same standard. The only thing I could say that I've told clients, well, someone comes in and, it's a young woman, and, you see the wedding ring on their finger, so, okay, they're married, they're young. Oh my God. The only thing you can really do is say, well, we give 2 weeks vacation, and here's the schedule, and you really, so many days a week, one night late, every other Saturday, and, are you going to be able to meet that schedule? Because remember, if people take time off because, like, oh, my babysitter didn't get here today, or I don't have childcare today, or my kid's sick and they're staying home from school, and they can't meet your attendance requirements, that's a legitimate reason to let someone go, because they can't meet the attendance requirements. So the one thing that you can do is you can talk about what the attendance requirements are, and then you can say, well, you're going to have to, if you get this job, you're going to have to meet these attendance requirements. And then see what they say in that situation. And that's really the only thing you can kind of do to deal with pregnancy.
All right, then we'll move on to disability.
Right, disability. Now it's that's where the issue of accommodation comes in. A small employer has a much better situation there of being able to avoid a tough situation, because for example, someone has no, they have Crohn's disease. And Crohn's disease is one of these chronic diseases that I've had to learn a lot about lately, where people periodically will have a flare-up and they're out. That's it. It's excruciating painful. They're home and they're out. So if someone has Crohn's disease, well, that's clearly a disability. It's a condition that they don't cure it. They can just manage it. And if that person keeps taking a lot of time off, and they're way beyond the amount of time that you allow under your policy, you could look to terminate that person for excessive absenteeism. And the fact that they have a disability and Crohn's disease is not going to protect them, because the standard is whether or not you can meet the essential functions of the job, notwithstanding your disability, or with a reasonable accommodation. Now, letting somebody have time off is an accommodation. But when you're a small employer and that person represents 1/4 of your workforce, and they've been out more than they've been there the last couple of months, that can be considered undue burden, and you don't have to continue to accommodate. The question always comes up is, where do you draw that line? There's no bright line. So I always tell clients, the minute that person with the Crohn's disease takes one more day off than your policy allows, I wouldn't suggest laying them off the next day. But you have to be just decide, okay, where's the breaking point? Where is it now too much that I can justify letting this person go? Keep in mind that under the state statute, they get four days of paid sick time that's required by 5 days that's required by statute. So they're entitled to that. And so you always have to keep that in mind in deciding those kinds of issues. But that's the biggest issue we see with disability.
And then next on our list is immigration status.
Right. Okay, so thank you. With immigration status, I mean, the real issue there is, now it's mandatory. You have to go on the federal website and check to see whether or not the person's Social Security card is in fact that person. Now, people, they can get anybody else's Social Security card. You're not required to do an investigation. You're not, but on the other hand, I had a client who said, Ben, I interviewed a couple of people today, and they had Social Security cards, and the numbers were in a sequential order on the cards. I was like, yeah, okay. I think maybe I don't think that's going to take a lot of investigation to decide that card those cards are bogus. So you do have an obligation to check the website to determine whether or not that Social Security card is legit. But as I was mentioning to Brent, when you look at a Social Security card number, you can to some extent decide how old the person is. So if they've got a Social Security card and the number is 140, that person's probably in their 50s or 60s. If they've got, I don't know, Brent, what's your first couple of numbers for yours?
Yeah, let's just give it our Social Security number. My first one.
Oh, the first three.
Nobody's right, because I see people around my age, and they're all, and there's a lot of 138s that are in there.
So so if you do that and you look and you say, wait a minute, this person's 20 years old and this Social Security card based on the numbers, obviously someone that's a lot older, you don't have an obligation to investigate as far as that's concerned.
All right, so moving on to our next section, which is other no-nos, sort of in the employment employment world and in the hiring world. The first thing I want to talk about is salary history. New York was one of the first states to implement a prohibition on inquiring about salary history, and the reason for that is it's viewed as a tool to combat the wage gap, meaning that if we had either women or other minority groups who were being traditionally underpaid, and they had to disclose at the time of application or interview what they were earning, it would perpetuate that. It would perpetuate the idea that that they're getting paid less, because now you're saying, oh, well, I'm going to give you a little bit more than that, as opposed to what the position's worth. And one thing we're going to talk about in their best practices is that in New York now, we actually have to set salary ranges or hourly rate ranges. And that's another tool, another legislative tool that's aimed at combating the wage gap. And so if when you're interviewing somebody or when you're putting an application together and collecting information, you have to make sure you don't ask about their salary history. Now, listen, there are times where you're in an interview, you're having a conversation with somebody, they start talking to you, and they will tell you what they make or what they did make.
Yes.
And it's important that in that instance, right, you can't forget that. You now know that it's in your head. It's important that you document that, hey, I was given this information. This was volunteer. I didn't request it. And so with respect to salary history, it's a standalone law. It's very important to know. We can't ask for it. And if you do, it's going to be a per se violation. But if that information comes up, make sure you document that it was given to you. Go ahead, Dan.
Yeah. Well, one thing, you can ask them what are you looking for in this position? What salary are you looking for? Yeah.
Absolutely. You have a right to know if what you're offering is what they're willing to accept. If your salary range on a position is, $50,000 to $60,000, and somebody says to you, I can't take a job for less than 75, then that's not the job for them. And they're not a viable candidate for you.
Right. The next thing, and I think we have to move this along so we get the best practices, which I'm sure everyone's interested in, is I actually sort of covered this already. No personal information, like what Brent was talking about earlier, and I, don't ask about their kids and this, because that's all. So it's all tied into protected categories. But if people volunteer things, like as I said earlier, I've got 3 kids at home that I really like, they volunteer it. If they tell you that, it's very important to document that they voluntarily gave you that information. And then, as I said earlier, do not follow up on it, because you can see how that ties into a protected category. The next thing is dealing with drugs. As a matter of fact, there was just a decision. It was New Jersey, but it dealt with marijuana. Since marijuana is now legal, someone brought a lawsuit saying that they were not hired because they tested positive for marijuana. If you're going to do drug testing, it is necessary for you to you have to disclose that during the interview process and get the individual's consent to do the drug testing as part of the application process.
In generally,
go ahead.
I was going to say, in generally criminal background checks, as it's been for the last few years in New York, it's called the ban the box law. And at the time of application and prior to a offer of employment being extended, we can't inquire as to employees' criminal backgrounds. Now, you can make a position conditional on clearing a criminal background check, and then when you do that, you have to make sure that the crime is, if you're going to rescind the offer, you have to make sure that the crime would be related to the work. That there's some reason why somebody who had that criminal background couldn't work for you.
And you have to write up an analysis.
Correct.
How you came to that conclusion. So, for example, if you find out that you have to do a criminal background check and they pled guilty to spousal abuse. Okay. Well, now you're in a dentist's office. You've got women patients. You may have young women patients. This obviously is someone who has been violent towards another person. I think that you could use that as analysis to say, no, we can't have someone with that kind of background. If you have someone who's at the front desk position and you're taking check, I know most people pay with credit card now, but some people pay with check. A few people still use cash unless you get very little, and they're going to have to deal with that, or they're going to have to deal with your accounts and whatnot. And they pled guilty to crimes of theft and deception. Okay, you can justify not hiring them, but you've got to do an analysis as to why and document that.
And finally, real quick, credit checks. That used to be a big topic. A lot of employers would run credit checks. What we'll recommend essentially for dental practices at this point there's very few instances. And in fact, Dennis and I really kind of racked our brains on this on Monday and try to think of what instance could we think of that would fit into the exception on the prohibition of credit checks. And we really couldn't come up with any. The New York law is very clear that ever since the 2015 amendments, it's really only intended to apply to sort of senior individuals who are really responsible for the finances of the organization, controllers, vice president, people in the finance office. You have to have sort of direct control and access over monies in excess of $10,000. And so at this point, there would be no exception that a candidate for a position at a dental practice would fit into that would make a credit check permissible. And that sort of brings us on to best practices, which is very important. We're going to be as detailed as we can as we run through this. So number one is job description. Everybody should have a job description. Create them for every position. Make them detailed. The reason, and we're going to start with have essential job duties and responsibilities. One, it assists with issues for disability claims. If somebody has a disability, they have to be able to fulfill the essential job duties and responsibilities with or without a reasonable accommodation. So we need to set forth what those job duties and responsibilities are so that we could say, well, this was essential and you need to be able to do it. It also helps us as far as establishing qualifications. If we're going to determine whether or not somebody's going to get a job, we want to have a job description that says, well, these are the qualifications for that position. This is the education that you need. And so somebody may say, well, I didn't get hired because I was a white man and you ended up hiring an African-American woman. Yes, well, she met our work experience qualifications and our education qualifications, and you didn't. And that was documented in our job description and our posting. And so that's why it's crucial. It doesn't take a lot of time. You can use them going on in perpetuity, but having that job description is very important. And Dennis is going to now talk about the other portions of the job description that you need to have there as well.
The other thing is work experience. I talked about a little bit before. So the way you deal with the issue that I raised there, say minimum, a minimum number of years. So you put the minimum, which is okay, but you don't say any maximum. Then I think you eliminate that problem. And then also, educational requirements. Again, so someone can't say, well, you didn't hire me because I'm in whatever protected category. No, you didn't meet the educational requirements, or someone else had more educational requirements than you did. One of the dental assistant had certifications where she could provide greater services. So these are all things that need to be in the advertisement for the job: the essential duties, minimum work experience, minimum educational experience, and availability. Because see, what you want to do with the job description, with the advertisement, you want to have people, what's the term that one politician uses? Oh, self-select. You want people. So if you have that conservative Jewish woman who's not going to work on Saturdays, you don't want, and that's going to be a problem for you. You don't want that person coming into your office to be interviewed. You want them to look at the advertisement and say, oh, every other Saturday, and hopefully that not have that person apply, so you don't have that problem that comes up. And then the other thing, which maybe we're pushing the envelope a little bit, is to talk about the patient base. If you're pediatric, you put pediatric patient base, or if you have a very diverse patient base, to say something innocuous, but sort of gets the idea of the patient base that you've got. I think the safest thing is we have a diverse patient base that you would have to be able to relate to, something like that. The next thing would be salary range. As Brent mentioned earlier, you now have to put in a salary range, and you can say that the salary is based on experience. The other thing too is very important with credentials is to have them provide them to you. I know you can look anybody up on the website to see what their current license is and whether or not they've had any disciplinary action against their license, but it's a good idea to make them substantiate that they have those credentials. So that's the important thing with the advertisement. And then when you come to the interview, you should go through every one of those elements as you interview the person, because that's what then, if for some reason you don't hire that person and they're in a protected category. And look at how many categories we've got. I mean, who's not going to be in a protected category, particularly in New York? Just about everybody. You can say, well, I went through the advertisement step by step and documented everything this person told me. So if you didn't hire them, you can show what element of that advertisement they didn't meet, which was the reason why you didn't hire them.
And in that interview process, documenting. Take notes about what the person's response was to their availability. Take notes as to what they stated they needed to earn. Take notes about their experience. And you want to save those notes because that's going to serve as the basis for your decision as to why you either choose to hire or not hire somebody. And you know, when you're interviewing them and you're trying to gain insight into whether this person's a good fit, you know, you can't come out, you know, if you ask somebody, you know, basic questions, you know, that try to get into whether they're a good fit, they can be good and dance around it. You know, some of the questions we like to encourage our clients to ask, and, you know, oh, so, you know, what worked and didn't work at your last employer? And that kind of gives you an idea. Is the person blaming everybody else for what was wrong there? Or are they somebody who accepted responsibility? You know, when you ask them, why would you leave that last job? Or why have you changed jobs so often? That can give you insight as to, listen, maybe it was somebody who kept getting offered more money. And like many people in this economy, when they're offered more money, they go. Or maybe it's somebody who has a hard time getting along with people. And we know one of the calls that we get all the time, Dennis and I get all the time, is, guys, this person is, I've got 6 employees in my clinical side, and this person's a cancer, and every day is becoming more difficult. And so those are the questions that you can ask to try to learn about that. And you want to document the answers to that. But then there's some questions you shouldn't ask. And Dennis is going to kind of give you a little insight here as to what those prohibited topics are.
Yes. So for example, one of the things that we were talking about is, when you look at the resume, hopefully, you know, you require that they have a resume, and you can see that they've had a job every year for, you know, a year and a half. They've never lasted more than another job. You can ask them, well, why did you leave that job? And how come you left this job? And what happened over here? As Brett was saying, those are things that you can ask, and you indirectly you can get information that will tell you whether or not this person is someone who's going to fit into your practice or not. You know, we have clients from a different background who talk about moral fiber. We like to interview people and ask them, you know, about their background, their family life, and wanted to see, you know, what their moral fiber is. And, you know, you cannot do that for all the reasons we talked about earlier. You can't ask people about, are they married? Are they not married? You got kids, you know, because all of those questions relate to being a protected category. But you can, as Brent was saying, talk about what you know, looking at their job history, what happened at each one of these positions, you know, that you left. So that's something that you can do. The other thing is, we talked about prohibited topics. We gave you all those prohibited topics earlier, just about all of them. As we said earlier, if someone volunteers some information about a prohibited topic, you should document that, and document the fact that they did volunteer. And then, as I said earlier, and then you do not follow up and ask them questions about that. Now, the other thing that we sort of talk about is record keeping. You should keep all the resumes of everyone, and you should keep all of your notes of your interviews. And at the end of your notes, you should list, like, why you did not hire this person. What was your thought process? What were the reasons why? Put that down in your notes. The reason why you want to do this, because it's a contemporaneous writing, which can be used. And you keep these notes for at least 2 years after the date that they were interviewed, because statute of limitations is 2 years. So you want to keep those notes for that period of time. The other thing is, whatever conditions you're going to have at the job. Some of this we talked about earlier. You should definitely tell them what the conditions are. In other words, what the requirements are, what they're going to be required to do, and if you have a particular patient base, and that patient base requires certain things, certain ways that that you have to deal with that patient base, you should lay those out and tell that person who's being interviewed, and document their response, because that is one way also that you can get some information to tell you whether or not this person is going to be a good fit. Because as Brent said, we get these calls all the time. This person's a poison. They aggravate everybody all day long, and they just told us that they're pregnant, and I got to get this person out of here. So you want to try to find out that information ahead of time, and to a certain extent, these are sort of indirect ways that you can do that without asking questions, that you shouldn't ask, because they relate to prohibited. They relate to prohibited topics that you can't ask about in the application process in the interview.
All right, so Katie, we have some questions two questions that you want to raise.
Yes. So one of the questions is, how often are these discrimination cases actually ruled in favor of the employee / prospective employees for small businesses? I find it very hard to believe that someone who was only interviewed and not hired could ever have a valid discrimination suit if the only reason the candidate is given for not being hired is that another candidate was a better fit. I think / hope that only blunt cases of clear discriminations are ever ruled in favor of the plaintiff. Is that accurate? I also assume big businesses are treated somewhat differently than smaller businesses.
So unfortunately, that is 100% incorrect. Now, listen, most cases, 96% of all disputes settle. So really only 4% of cases ever go to trial. But many of these cases end up settling sometimes for nuisance amounts, because there's a lot of strong evidence in the record, the employment record, the personnel file, the interview history that shows that. But other times there isn't. Let me give you an example. So what the law says is the plaintiff has a very limited low bar here. The plaintiff has to show that I applied for a position, I was qualified for the position, and I wasn't hired for it, and that somebody else of a different protected class. So somebody, if I'm African American, somebody's white. If I'm male, they're female. If I'm straight, they're gay. That they were hired, and that's their burden. And then that burden switches to the employer, who has to be able to articulate a legitimate, non-discriminatory reason for why that decision was made. And that's why all the times that Dennis said that you need to document, you need to ask these questions, you need to save this is important, because when that burden switches from the employee, they meet their limited burden. Now the employer has to be able to show the court that here's my legitimate non-discriminatory reason for why I hired this Caucasian male over African American female. If there's no documentation or support for that, then there's a question of fact. When there's a question of fact, then that's what goes to a jury, and that's very expensive. Very expensive.
Let me add on to that. What the person asking the question said, they weren't a right fit. That's a conclusion. That will get you nowhere. I tell employers, no, you just gave me a conclusion. You need to tell me what factors did you take into account that brought you to the conclusion that this person would not be the right fit. And you say, well, they never held the job for more than a year and a half. And when I asked them for each one of the jobs why they left, they always had some excuse, and it all related to their interpersonal relationships with other people at work. These people are a bunch of jerks. I couldn't get along with this one. This one over here, just they had it in for me. So simply to say that it was not a fit is not going to go anywhere. That you've got to have, what are the reasons for that? And I will tell you that plaintiffs' lawyers target small employers. No one's going to target a Wall Street firm and say, well, you discriminate against me and hiring me for the front desk, because that Wall Street firm will litigate that plaintiff's lawyer to death. And remember, the plaintiff's lawyer only gets paid if their client gets paid. But I will tell you, particularly now, I've got a couple of cases, I'm sure Brent does too. We're in federal court, and who are they suing? They're suing dental practices with a couple of employees because they know that they don't have the ability to defend, and a lot of them don't have employment practices liability insurance. I'd love to, if we could take I'm sure we can't do that. I'd love to see a show of hands. How many practices have employment practices liability insurance? I'm sure very few. These big employers have insurance, and stacks of lawyers. So it's really the small employers that get hit with these kinds of lawsuits, because they know, the plaintiffs' lawyers know it's an easy, quick hit for the nuisance value of it, because they know that employer probably doesn't have insurance and can't afford to defend the case.
We actually,
doesn't have an HR department that's been trained up and down and knows exactly what to do and has everything documented to the hilt as to why that person wasn't hired. You don't have that facility.
Next question, Katie.
Could an office be vulnerable to a lawsuit if they have only had female management employees throughout their history?
The answer, only having female employees in and of itself is not a violation of any law. The issue becomes if there's male candidates who are regularly interviewing and they're never ever hired. Many industries tend to skew towards a certain demographic. I mean, there's the education, dentistry, veterinary, baking. I mean, you could go across all industries, and there's some industries that traditionally have one gender over another. So that in and of itself isn't an issue. It only becomes an issue if people are coming in of another gender, another race, another age, and they're never ever being hired.
Yeah. So for example, if you have, if your entire support staff is all female and a guy comes in who wants to interview for the office manager position, and he's beautifully qualified, but you say, you know what, the women I have here, they're not going to take kindly with having a guy telling them what to do. That would be, that I would see that as being a problem there, because there you're making a decision, based on the person's gender.
We have one last question. A dental assistant has been temping for me. After a few months, she reached the amount of days work that she can now be hired. We decided to go through with the hiring process, but didn't begin it yet. She now told me that she may need foot surgery in the next few weeks, and recovery is about 6 to 8 weeks. Nothing has been promised to her on paper, just words. If she does need surgery, can we retract that verbal offer?
No. Well, I mean, listen, this is where we say we can't give out legal advice. Depending on what type of hardship it would create on the practice, how long she would be out, but generally in and of itself, an employee who has a medical condition, right? They're a temporary employee who was made a promise of employment for full-time or regular employment. And in retracting that would be what's known as an adverse employment action. And unless the impact of that person going out would create what's known as an undue hardship, which Dennis touched on a little bit earlier. Unless it satisfies that standard, you're kind of walking right into a lawsuit.
Yeah, I mean, in that situation, you've offered them the job. They're going to be out for 6 weeks, even though it's temporary. It's just 6 weeks. The definition of disability has been so watered down that it's quite possible that will be considered a disability. So the fact that you'd have to keep the position open for 6 weeks, that a few other people might have to work some overtime, you might have to bring in a temporary. In the current context, I don't think any of that would be considered, an undue hardship. It used to be undue hardship meant if it cost you anything more than a few bucks, but now the bar's been raised higher and higher. So any of the sort of inconvenience it would cause you for a few weeks waiting for her to come back, I doubt that would be considered a sufficient undue hardship that you wouldn't have to accommodate her taking that time off.
If we have time for one more question came in.
Yeah, that's it.
Is it a valid reason not to hire someone because they are overqualified? For example, a person with a history of being an office manager applies for a receptionist job. Is that discrimination?
No,
No,
no.
listen, it's something that we actually deal with a lot in the terms of when there's restructuring or sometimes reductions in force. And, if there's no union and there's no bumping rights, people have to deal with the fact is is an employee really going to be happy, and are they going to be invested in a
Right.
position that they're overqualified for, and that they are they just going to be here, be upset, or already be looking for another job, and so that's regularly.
It's fine.
Now listen, now you can't say because they have many years of experience, that gets into the age discrimination issue that Dennis talked about. But as far as somebody who was an office manager applying for a
Front desk
position, it's reasonable to say I don't think this is somebody who's going to be a fit here because they've done something above that, and are they really going to be invested in this lower level position?
And the biggest issue there is they're not going to stay. So, that's clearly not discriminatory.
Well, thank you both for your time and knowledge.
Oh,
It was very,
you're welcome.
very informative.
Good.
Glad to help everybody
Bye.
today. Glad to present, and of course, at any time, if anybody has any questions, you certainly can get Dennis's or I's contact information and reach out to us at the firm.
Yes, we provide that as a service for people who are members of the society. You can get you can have an initial 10 or 15-minute consultation with us. It's a service that we provide as a benefit to you as members of the society.